We'll hear argument this morning in Case 14-11-4, King v. Burwell. Mr. Carvin.
Mr. Chief Justice, and may it please the Court, this is a straightforward case of statutory construction where the plain language of the statute dictates the result.
Mr. Carvin, will you please back up, because before we get to a question of statutory construction, as you know, each plaintiff, or at least one plaintiff, has to have a concrete stake in these questions. They can't put them as ideological questions. And we have four plaintiffs. As to two of them, there is a declaration stating, I am not eligible for health insurance from the government. But there's a question of whether they are veterans eligible for coverage as veterans.
Yes, one of those is Mr. Hurst, who would have to, if I would refer you to the joint appendix at page 42, where this is the government's recitation of facts, where they make it clear that Mr. Hurst would have to spend $750 of his own money because of the IRS rule. Mr. Hurst was a veteran for 10 months in 1970. He is not eligible for any veterans service because if you've served such a short health services, if you've served such...
I'll ask the government if they agree that...
And I should point out that the government has never disputed this, and I'd also...
But the court has an obligation to look into it on its own.
That's true, but of course there has been fact-finding by lower courts in an adversarial system. I don't believe the court does its own.
I don't think it was ever brought up in the lower court that these two people were veterans. If
I could make one further point on this, Justice Ginsburg, even if he were technically eligible, which he is not, there's a IRS rule 26 CFR 1.36b 2CII, which says you will,
yes,
with the usual clarity of the IRS code, making clear that you are only disabled from receiving subsidies if you have actually enrolled in a veterans health services, and it's undisputed that Mr. Hurst
Mr. Hurst if that's their position too. And then there were the two women. I think one of them was going to turn 65 in June, which would make her Medicaid eligible.
She will turn 65 in late June. She's obviously subject to the individual mandate well in advance of that. By virtue of the IRS rule, she would have to spend $1,800 per year for health insurance by virtue of the IRS. Excuse me?
But you said she will turn 65 in June.
Late June, yes.
So that takes care of 2015.
No. Right now, she is obliged under the individual mandate to have insurance. You have to have insurance for 9 months of the year. And so as of April 1st, she will be subject to the penalty, which will be alleviated only by...
Again, I'll ask the government if they agree with you on that. And then I think for the fourth plaintiff, there's a question whether she would qualify for a hardship exemption from the individual mandate, even if she received the tax credit, in which case the tax credits would be irrelevant.
That's true. Again, I'll refer you to the joint appendix at 41. That was the government's argument below. We didn't want to get into a factual dispute about it because we had such clear standing with respect
but you would have to establish the standing, prove the standing, if this gets beyond the opening door.
Fair enough, Your Honor, but it's black-letter law that only one plaintiff needs standing, and for the reasons I've already articulated, both Plaintiff Hurst and Plaintiff Levy have.
I don't want to detain you on this anymore, but I will ask the government what their position is on standing.
Thank you. Returning to the merits, the only provision in the Act which either authorizes or limits subsidies says in plain English that the subsidies are only available through an exchange established by the state under Section 1311.
If you're going to elaborate on that, I would appreciate in your elaboration. I've read that, and this statute is like the tax code more than it's like the Constitution. There are defined terms, and the words you just used concern a defined term. Now, as I read the definition, there's a section, definitions, and it says, quote, the term exchange means, quote, an exchange established under 1311, and 1311 says an exchange shall be a government agency, etc., that is established by a state. Those are the definitions. So then you look to 1321. And 1321 says, if a state does not set up that exchange, then the federal, quote, secretary shall establish and operate such exchange. So it says the secretary is to establish and operate such exchange, the only kind of exchange to which the Act refers, which is quote, an exchange established by a state under 1311. That's the definition. So the statute tells the secretary, set up such exchange, namely a 1311 state exchange.
Correct.
And there's nothing else in this statute.
Correct.
So that's throughout what they're talking about. So what's the problem?
As Your Honor just said, it tells the secretary to establish such exchange.
Yes.
And what 36B turns on is whether the state or the secretary has established
No,
such
it
exchange.
uses the same terminology that it's used in 15 times in this statute, namely the terminology in the definition is an exchange established by a state. That's the phrase.
Well, under 1311, that is the phrase. And if 1311 created the definitional section created some ambiguity as to whether HHS was establishing a 1311 or 1321 exchange, that is immaterial, because 36B does not say all 1311 exchanges get subsidies. It says exchanges established by the state under Section 1311, not established by HHS under Section 1311. So it eliminates any potential ambiguity created by the definitional section.
Can I offer you a sort of simple daily life kind of example, which I think is linguistically equivalent to what the sections here say that Justice Breyer was talking about? So I have 3 clerks, Mr. Carvin. Their names are Will and Elizabeth and Amanda, okay? So my first clerk, I say, Will, I'd like you to write me a memo. And I say, Elizabeth, I want you to edit Will's memo once he's done. And then I say, Amanda, listen, if Will is too busy to write the memo, I want you to write such memo. Now my question is, if Will is too busy to write the memo and Amanda has to write such memo, should Elizabeth edit the memo?
If you are going to create monies to Will for writing the memo, and Amanda writes the memo, and you say the money will go if Will writes the memo, then under plain English and common sense, no. When Amanda writes the memo,
you run a different shop than I do, if that's the way. Because in my chambers, if Elizabeth did not edit the memo, Elizabeth would not be performing her function. In other words, there's a substitute, and I've set up a substitute, and then I've given instructions. Elizabeth, you edit Will's memo, but of course if Amanda writes the memo, the instructions carry over. Elizabeth knows what she's supposed to do. She's supposed to edit Amanda's memo too.
And in your chambers, you're agnostic as to whether Will, Elizabeth, or Amanda writes it. But the key point here is under Section 1311, Congress was not agnostic as to whether states or HHS established the exchange.
Well, Mr. Carvin, if I had those clerks, the same clerks, and Amanda wrote the memo, and I received it, and I said, this is a great memo. Who wrote it? Would the answer be it was written by Will because Amanda stepped into Will's shoes?
That was my first answer. Justice Kagan didn't accept it, so I'm going to the second answer, which is you are agnostic as between Will and Amanda, but Congress was not agnostic as between state and federal exchange.
That's a very important point, I think, because what you're saying is that the answer to the question really does depend on context. And it depends on an understanding of the law as a whole and whether they were agnostic. I agree with that. So it's not the simple 4 or 5 words. Because the 4 or 5 words in my example, it's obvious that Elizabeth should edit the memo. It's the whole structure and context of the provision that suggests whether those instructions carry over to the substitute, isn't it?
We implore you to examine these words in the context of the Act as a whole, because our argument becomes stronger